what will be the consequence if we, of course, if we don't allow the speaker to take action the moment a notice of resolution is issued, that according to you would result in a very serious consequence. But on the flip side, what would be the consequence if we allow the speaker to participate even when the stage of, say, the grant of leave is crossed? What would be the argument on the flip side?
No, but there have to be 29 members have to support that. He cannot decide.
No, 29% MLAs have already supported, and the leave is granted.
If they've supported, and leave is granted,
Correct.
and leave is granted, then the day.
Mr. Chief is my learned brother will explain what was falling.
Was asking you is, what will be the consequence of the speaker continuing to decide the 10th schedule proceedings while a proceeding is pending after issuance of the notice?
As I said,
that's the question.
Yes, as I said.
Other line of, it should be seen in the context of other line of judgments on the 10th schedule, saying why is he in such a hurry to decide? There must be sufficient time.
Let me Milad, answer that straight away, Milad. Now, you are interpreting 179 to mean that the speaker will continue to discharge his functions as a speaker till the motion for his removal is put to vote.
Correct.
The purpose of
Correct.
Correct, Milad?
Correct.
He has no disability.
Correct.
Correct? And till it is put to vote, the motion may never be moved.
Correct.
May never be moved, Milad.
So,
Mr. Sybil, what is worrying me, of course, is sorry, Naseema.
No, go ahead.
What is worrying on the other hand is this. He's just putting it to you. On the other hand, if you say that, well, he can take all action, including on deciding on disqualification, until the motion is put, the day he's put to vote, the consequence then may also be this, that he can affect the motion for his own removal by deciding upon the disqualification.
I tell you, Lordship.
That's so desirable.
No, that I tell you, Lordship.
That
There's a difference there. There's a difference there. Mullad's, his removal by the House is not subject matter to challenge. It's a legislative process. Internal to the House. A disqualification in the same schedule, subject matter of challenge. Judicial.
Person is wrongly disqualified.
Person is wrongly disqualified. Your Lordship have so often intervened. Set it aside. You can go back.
But of course, therefore, then we'll also have to factor in. The sense of your submission is that though a speaker then can, by deciding upon the disqualification issue, essentially affect the course of his own removal.
No, but that is your Lordship is assuming that he will discharge his functions in a malified manner. That's your Lordship may have to make that constitutional assumption. And the whole purpose of Geruto Holohorn.
Ultimately, that was the whole basis of your initial submission.
No,
Support who will.
because I am being an arbiter in these matters at all. So that's another matter. That's nothing to do with it.
The only thing which seems to have reached the court is that's really, otherwise constitutionally your argument is, I mean, obviously, prima facie, your argument on reading 179 and 181 are very clear. But now the only point is this, that by giving the power to a speaker, are we then going to essentially give the speaker the ultimate power to decide upon the course of his own removal?
No, it's not the course of his own removal, it's the course of the removal of those who have actually voluntarily given up membership of the party. This is not a question of course of his own removal.
Yeah, that's
Because he belongs
That will tilt the balance.
I'm sorry?
That may tilt the balance.
But it will balance. If they have voluntarily given up, it will tilt the balance. Why should it not tilt the balance? Why should it not tilt the balance? If actually, kindly forget about, now let's go into just a short summary of facts. In this case, what happens? In this case, what happens is this notice is given. This court says they can reply by 12th of July.
right.
And the government falls in the meantime. And we are 8 months down the road. He has not even given notice on our disqualification petitions. No, the person has not moved the notice and the speaker has not given a notice on disqualification petitions. I mean, you have seen, now see the.
So according to you, the speaker was well within his right to disqualify anybody in the meantime as well.
Because of the facts which are undisputed. You had a new government with the support of these people. What else is it but voluntarily giving up membership of the party? And then, Manoj, that the argument is he is going to decide his own fate. No.
Now, Mr. Sibal, we saw the first part of Nabam Rebia where Justice Keir puts it as a matter of ethical grounds. Now, how does he interpret?
Yes, I was going to read that.
Well, let's just
we'll
read
go
that.
that. We'll go
So
further.
that's the next step
Yes.
to cross on Nabam.
Yes, absolutely.
I didn't want to interrupt the speaker when they said that the fresh disqualification notices after the new speaker took over were not issued for 8 months, because during that hearing in the Supreme Court, everyone decided that while your lordship are seized of the matter, the speaker would not precipitate the matters or proceed further. So to say that he did not act on those notices is completely incorrect, because that was something which was agreed to by the parties. What was not agreed to by the parties was EC being injuncted, which your lordship decided. But the other issue was, when we all were here, we all were ad item on the fact, let it not be precipitated. It's a very wrong impression being given as if the speaker has been sitting and not even issued notices after that.
Because he issued notices against us. He said, we should notice again, despite what my learned friend is saying. So what's the point of this kind of interjection? He selectively issued notices. There was no bar as far as he is concerned to issue notice to us. But there's a bar as far as notice to their own people. What kind of intervention is that?
To both the
Anyway, one second.
Both parties.
One
Now,
second.
now let's, Mr. Sibal, for a moment, we're not clouding our mind on the correctness of Nabam, on the facts of this case. That
Yes.
would be a very improper. We must
Yeah.
look at it straight on as a constitutional issue.
Yes, I agree, Malaj. I'm only saying, yes, absolutely. If you're, Malaj, the point is there are two. Later, Malaj, they are also interpreting the word then members of the assembly.
Yes.
And you'll have to look at that. Malaj.
Let's see that now.
Yeah.
Para 190 and
190, Malaj, let's read that further.
That's the only ground of.
Yes, that's the only ground. Which is also, according to me, constitutionally erroneous, but we'll argue that later. Just like the other provisions of the Constitution interpreted by us here in above, it would be apposite to ascertain the desired intent of the framers of the Constitution emerging from the Constituent Assembly debates with reference, I'm sorry, your lordship had that?
yes.
Para 190. With reference to Article 179C. In the draft Constitution, the present Article 179 was numbered as draft Article 158. One of the issues debated with reference to draft Article 158 small c was with reference to the words, quote, all the then members of the Assembly, unquote, used therein. The above words were used to define those who would participate in the motion for the removal of the Speaker. Needless to mention that the said words were retained in the final draft in Article 179C. One of the members of the Constituent Assembly had suggested substitution of the above words by the words, the members of the Assembly present and voting, as under CAD volume whatever. Mohammed Tahir, sir, I beg to move that in clause C of Article 158, For the words, all the then members of the assembly, the word, the members of the assembly present and voting be substituted. In other words, the majority not be counted in the context of all the members of the assembly, but only those who are present and voting. There, sir, as far as I can understand, the meaning of the wording, all the then members of the assembly, it includes all the members of the assembly. Supposing a house is composed of 300 members, then it will mean all the members of the assembly, that is 300. Supposing 50 members of the house are not present, then those members will not have the right to give their votes as far as this question is concerned. Therefore, I think it would be better that this matter should be considered by only those members who are present in the assembly and who can vote in the matter. In this phrase, all the then members of the assembly means the members who are present in the assembly. Then I have no objection. If it means all the members of which the house is composed, I think it is not desirable to keep the clause as it stands. With these few words, I move my amendment. The Constituent Assembly debates do not appear to have recorded any discussion on the above amendment. The decision on the proposed amendment was, however, minuted under so-and-so. Mr. President, the question is that in clause C of Article 158, for the words all the then members of the Assembly, the words the members of the Assembly present and voting be substituted. It is apparent that the Constituent Assembly chose to retain the words all the then members of the Assembly and declined to substitute them with the words the members of the Assembly present and voting. We are of the view that the acceptance of one set of words and the rejection of the suggested substitution would effectively render a constitutional answer to the issue. Article 179C provides that a speaker or deputy speaker may be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. A notice of resolution for the removal of the speaker or the deputy speaker of the Assembly would therefore have to be passed by a majority of all the then members of the Assembly. The words all the then members included in Article 179C are a conscious adage. If the words all the then members were excluded, then clause C of Article 179, it would have that.
This really means that all the members of the assembly means
That's right.
that you have to meet a higher threshold.
Correct. That's like in the judges removal, brother. The
If you have
judges
a 300 have a motion for removal passed, you must have 151.
That's right.
But what it means is that instead of 300, you have say 90 present that day, and people are not well.
Still 151 will have to.
Still 151.
Absolutely.
50% of 190.
Correct.
So the threshold required is given the strength of your assembly.
That's right.
All that
This is the constitutional logic, Mullah, that they have used.
they say that, well, because the constitutional provision says all the members of the, that means that the speaker has no power to decide upon the disqualification of his own, not according to the secretary.
Doesn't seem to be constitutionally
And
logical. Mullah, for example, when a judge is removal,
because you can't compel a member to attend.
Yes, yes.
So somebody is down
Well,
with a serious medical issue.
no, not only
It
that,
doesn't require a disqualification.
not only that, how do you bring back a man who has died, Mullah?
As of that date.
You can't bring him
There would
back.
be a vacancy.
Then members, he is frozen. Well, unfortunately, you can't bring him back. No matter how we think. So you can't bring him. A man who resigns, How can you prevent a resignation? The freeze on the date of the notice, you can't freeze the numbers of the House. So completely.
Read further, Mr.
Yes, I'll read further. So others,
This is, I think, the only paragraph.
then members excluded from clause C, it would affirm the interpretation of the appellant. The connotation placed by the appellant would legitimize the action of the speaker in going ahead with the proceedings under the 10th schedule, even though notice of residence for his the speaker was pending. The words "all the then members" consciously added in 179C, and this substitution was not accepted by the Constituent Assembly. We are satisfied with the words passed by the majority of all the 10 members of the Assembly would prohibit the Speaker from going ahead with the disqualification proceedings under the 10th schedule, as the same would negate the effect of the words "all after the disqualification of one or more MLAs from the House." The words "all the 10 members" demonstrate an expression of definiteness. Any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of residence of the Speaker or Deputy Speaker is pending would conflict with the express mandate of 79C, requiring all the then members to determine the right of the Speaker to continue. It would also be relevant to notice that the 10th schedule was inserted in the Constitution by the Constitution's 73rd Amendment, Act 1992, with effect from 24/1990. Well, this is also wrong. It is by the 52nd Amendment, not the 73rd, introduced in 1985, not 1993. This is also somehow error is.
Next para. No, next.
The purpose sought to be achieved through the 10th schedule is clear and unambiguous. The same is unrelated to and distinct from the purpose sought to be achieved through Article 179C. Neither of the above provisions can be seen as conflicting with the other. Both must therefore freely operate within their individual constitutional space. Each of them will have to be interpreted in a manner as would serve the object sought to be achieved, without spreading into the constitutional expanse of the other. The interpretation would have to be such as would maintain constitutional purpose and harmony. We would now venture to examine the present issue, the above perspective in the following. Now, if this is right, if
193 also. Next para also is.
Yes.
Please read.
If the Speaker survives the vote on the motion for his removal from the office of the Speaker, he would still be able to adjudicate upon the disqualification petitions filed under the 10th schedule. The process of judicial review cannot alter the above position. But if a disqualification petition is accepted by the Speaker, the disqualified MLAs will have no right to participate in the motion moved against the Speaker under 179C. A disqualified MLA, as we all know, can assail the order of his disqualification by way of judicial review, which is what I was saying, Melissa. If he succeeds and his disqualification from the House is set aside, such a disqualified MLA would be deprived of the opportunity to participate in the motion of the Speaker under 179C. In this situation, the process of judicial review can also alter the position if a disqualification order passed by the Speaker is set aside by a court of competent jurisdiction. In the event of an MLA having been disqualified by the Speaker, the notice of resolution for the removal of the Speaker would surely be dealt with and will be disposed of during the period when the MLA concerned is disqualified. Alternatively, if an MLA has not been disqualified when the motion for removal of Speaker is taken up, he would have the right to vote on the motion pertaining to the removal of the Speaker, whereafter the petition for his own disqualification would certainly be considered and decided by the Speaker. It is apparent that the difficulty arises only if the disqualification petition is taken up first and the motion for removal of the Speaker is taken up thereafter. That is where that comes from. The possibility of a disqualification petition being decided on political considerations rather than on merits cannot be ignored. This works both ways. Doesn't work one way. In fact, that is a real possibility. Therefore, while it will not adversely affect the Speaker if he faces the motion of his own removal from the office of the Speaker before dealing with the disqualification petitions, it could seriously prejudice MLAs facing disqualification if petitions for their disqualification are taken up and dealt with first. The adoption of the former course would also result in meaningfully giving effect to the words "all the then members."
So everything comes down to all the then members.
That's correct. That's correct.
The last three lines also.
Members used in the Article 179C, as discussed in the foregoing paragraph, This interpretation would also purposefully give effect to the rejection of the amendment suggested during the Constituent Assembly debates that the motion for removal of the Speaker should be the majority of the members of the House present and voting. This interpretation would also result in disregarding the retention of the words all the then members of the Assembly in Article 179C. If the Speaker faces the motion of his own removal first, both the constitutional provisions would have their independent operational space preserved. None of the constitutional provisions concerned would interfere with the free functionality of the other, nor would one usurp the scheme postulated for the other. We're therefore of the view that constitutional purpose and constitutional harmony would be maintained and preserved if a speaker refrains from adjudication of a petition for disqualification under the 10th schedule, whilst his own position as the speaker is under challenge. This would also allow the two provisions, 179C and the 10th schedule, to operate in their individual constitutional space without encroaching on the other. For the reasons recorded above, we hereby hold that it would be constitutionally impermissible for the Speaker to adjudicate upon disqualification petitions under the 10th schedule, while a notice of resolution for his own removal from the office of the Speaker is pending.
That's the one.
And Millet, we have in our note, and I will show that to your lordships presently, there are other provisions in the Constitution where the expression then members is used.
Actually, this,
And Millet, that has been interpreted. Sorry.
no, actually, as Madan Lokur's judgment says,
I can't hear you.
as Justice Madan Lokur's judgment says, this was not necessary also to
Exactly,
decide.
exactly. It was not
Because it was
necessary for
the-
the case. I don't know why the judges went into it, because Justice Mishra, I was in that matter, raised this issue on his own and said we must also look at it.
Really, 9th December 15th decision of the governor was the real.
That's correct. That's set out in the first paragraph of the judgment itself. It's really all arbiter. It's really not.
Very preponed the
Yes.
meeting.
Preponed and sent a message saying how you will consider. So both the message was struck down and the preponing of the session was struck. That's what really happened.
Of
This
course,
really
the
was.
subsequent decision of the deputy speaker reversing the speaker's order.
That's right. And declaring
That
that
was
to be
another.
void. That also. But the disqualification matter then went to the Guwahati High Court, Manoj, and there they were decided one way or the other.
Initially, Ladit Singh stayed the entire proceedings.
Correct. So the issue, Manoj, the issue is simple. Assuming, and let's put it, your lordship was Manoj putting to me that you are also concerned with the other aspect as to why he should be allowed to continue. Let's assume he is not allowed to continue. But who will then decide under the 10th schedule? The petitions are pending, no?
But on facts of the present case, is it because of the principle in Nabam Rebia that the problem has arisen for you, or is it just that the
Yes.
judgment is wrongly decided? Refer to a large implication on your case.
The implication is very serious because on 27th, because of these
Give us
two
the
arguments.
What are the dates of your?
I'll just tell you, Lordship, brief the order. On the 27th, when this was passed, the order saying, give them till 12th of July. Time till 12th of July. Then, Maharaj, obviously, these people were legitimately members of the assembly. So then they, Maharaj, went to the other side, and the new chief minister was sworn. Maharaj, in fact, an elected government was toppled through this procedure.
Right. Now let's see how Justice Mishra deals with
Yes,
it.
Justice Mishra also.
Yeah.
Yes,
And then Justice Malik.
that's correct. One one four two. 1146, Maharaj.
Justice Narasimha Sari, the foundation of the interim order in this case, when it's started, is Navim Rebia, mentioned. And thereafter, the entire notice disabling is based on that.
See.
Foundation is that.
1142.
46. Yes.
No, PDF. Tell us.
115 PDF, 1146 will be there.
Mishra.
Yes.
What is the para number?
Yeah. Oh, God, sorry. Sorry. Yes.
Are you referring to Justice Mishra's Calcutta?
Yes.
Okay. Para 216, shall I say 215?
He quotes Article 179.
Yes, 215.
And then at 218, Mullah, he starts discussing, if I may read that.
115 PDF.
The thrust of the matter. Para. The 217 Mullahs, the learned judge quotes 179.
Yes.
The thrust of the matter, if your lordships have it, I'll. Thrust of the matter is what interpretation is to be placed on Article 179C and the first proviso, being diligently and respectfully adherent to the norms of constitutional interpretation. I may state with quite promptitude, purpose of adherence should not convey that one can find any kind of static principles that flow from our organic by text and passionate constitution. Passionate is a very form. Politics is always lack of constitution. Anyway, there are presidential guides, and if I allow myself to say constitutional precepts, would serve as a light posts without causing any violence, even remotely, to the language employed. Then Mullahs quotes Karnataka. Let's not go it out. Your lordship want me to read, I will read, but I don't think it's.
No.
In verse 220, the aforesaid paragraphs clearly convey that judicial interpretation cannot nullify, defeat, or distort the constitutional provision of the interpretive process, cannot in direct conflict with the express provision of the Constitution. However, the learned Chief Justice has observed that constitutional document has to be read as a whole and construed keeping in view the declared objects and functions. In the said judgment, a distinction has been drawn between constitutional law, the fundamental law, the laws which may be important constitutional matters. I think it appropriate to reproduce. When those passages are reproduced. It's para 223. With giving the Constitution a purposive interpretation, and it just relies on all those judgments. Then 223 paragraph. I have referred to the aforesaid pronouncement as they have laid down the guidelines for the text, context, the words and the purpose of a constitution. Emphasis is on flexibility, adaptability, and durability, and also not to import or implant an interpretation which would be in conflict with the express language of the Constitution. Having received the guidance from the precedents and keeping in view the cohesive constitutional precepts, I shall proceed to analyze the language of 179C. Prior to that, I think it convenient to dwell upon the importance of the office of the Speaker. There is no shadow of doubt in my mind that to appreciate the significance of the provision, namely 179C in the context of constitutional supremacy and constitutional consciousness, it is necessary to understand the position of the Speaker. The Constitution. Office of the Speaker in our history had its origin in 1921. The Legislative Assembly was constituted. Mategu Tenth Reform. That time, Office of the Speaker did not enjoy much importance, but a significant one after the Constitution came into force, as is evident from the constitutional scheme of ours. The Speaker enjoys high constitutional status, and the Constitution reposes immense faith in him. For this reason alone, the Speaker is expected to have a sense of elevated independence, impeccable objectivity, and irreproachable fairness, and above all, absolute impartiality. This expectation is a constitutional warrant, not a fond hope, an expectation of any individual or group. The Speaker has the duty to see the business of the House is carried out in a decorous and disciplined manner. The functioning requires him to have unimpeachable faith in the intrinsic marrows of the Constitution. Constitutionalism and rule of law, the faith, needless to emphasize, should be visible and apparent. That is why possibly former Speaker of the House of Commons in the UK, Baroness Boothroyd, when you have been committed all your adult life to the ideals and policies of one party, impartiality is a quality that you have to work at. But if you cannot put aside partisanship, you have no right to even think of becoming the Speaker. I have referred to the aforesaid only to stress upon the impartial functioning of and constitutional neutrality of the Speaker. The expression can be different. One wishes to choose the ancients. The ancient wisdom would require the Speaker to abandon his Ram and get wedded to Parashram. To elucidate, a Speaker has to constantly remain in company with the cherished values of incarnation of his office and not deviate even slightly from the constitutional conscience and philosophy.
Actually, para 233 and 235.
That's right.
233 is the real para.
Notice how far removed are these words from reality is something that we can take notice of. 233. 233, Madam?
Yes.
There can be myriad situations of democracy. The Constitution as an organic instrument has to be interpreted to meet all exigencies. It has to have the resolution for removal of the Speaker, the office immediate to the Speaker, on a complaint initiates action under the schedule. As the resolution against the Speaker cannot be moved unless 14 days expires. Notice period expires, the members can be disqualified within the said period, and the Speaker would gain an advantage. Thus, it can result in a situation of conflict, that is, conflict between the status of a Speaker conferred by the Constitution, the position he has been after the constitutional amendment. The final arbiter have trusted him regard being had to his constitutional status. It is the constitutional trust, therefore, there should be perceptibility of absence of conflict. That apart, it will not be in harmony with Article 179C or the constitutional norm. It would also cause discord with the language employed in the said article. The founding fathers had deliberately retained the words all the then members by negativing the proposed amendment. The purpose of not accepting the amendment is to preserve the constitutional control over the situation. In this regard, I may usefully refer to 189 of the Constitution. It provides for voting in houses, power of houses to act notwithstanding vacancies in quorum. Clause 1 of Article 189 stipulates that save as otherwise provided in the Constitution, all questions at any sitting of a House of the legislature of a state shall be determined by a majority of the votes of the members present and voting, other than the Speaker or Chairman or person acting as such. The said clause also provides that Speaker or Chairman or person acting as such shall not vote in the first instance, but shall have the exercise of a casting vote in the case of equality of votes. The said clause thus clearly states that the majority of votes of the members present and voting, and secondly, it empowers the Speaker to exercise his power of voting in case of equality of votes. In contradistinction to the same, 181 provides that the Speaker or the Deputy Speaker is not to preside while resolution for his removal from office is under consideration, and he is entitled to vote in the first instance on such resolution, but not in the case of an equality of votes. Article 181(2), which is relevant for the present purpose, reads as follows. We've read that. The purpose of referring to the said article is to highlight the nature of participation of the Speaker when the question of his removal arises. It is clearly different. Under the Constitution, he is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution, especially keeping in view the language employed in the first proviso to Article 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest till the resolution is moved. In this regard, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers to the Speaker while deliberating on the constitutionality of the said schedule. The majority in so and so has stated and follows. Losses may leave that, we know. Then verse 237. The aforesaid reasoning eloquently speaks of the power, position, and status of the office of the Speaker enjoys under the Constitution. It also states that the scope of the fiction, the court has constricted the power of judicial review restricted it, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority, jurisdiction exercise the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional value sustained democracy in a sovereign republic. The Speaker is expected to maintain propriety with an adjudicator. The Speaker, when functions as the tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, such impartiality should be perceptible, be beyond any reproach. It must reflect the trust imposed in him under the Constitution. Therefore, the power which flows from the introduction of the 10th schedule by constitutional amendment is required to be harmoniously understood in 79. Provisions of the Constitution are meant to subserve the purpose of sustenance of the basic feature of the Constitution. Speaking about democracy in India as a product of the rule of law is only a political philosophy, also an embodiment of constitutional philosophy. thus regard being had to the language of 179C and the role ascribed to the speaker. It is necessary that the speaker of the tribunal have complete and procedural. When there is an expression of intention to put the resolution removed, it is requisite and then proceed. That is the intent of 179C. Said interpretation served the litmus test of sustained democracy founded on the rule of law. Founding fathers had so intended, and the constitutional value, trust, and morality unequivocally so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the schedule. After intention to remove him, is removed. 14 days period being mandatory, the words all the then members gain more significance. The constitutional confidence in the Speaker, I would like to call it repose of constitutional confidence. Simultaneously, the can't have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution. Clearly brings in harmony between constitutional confidence or trust and the constitutional control. It is stated the position has to remain the same even after introduction of the 10th schedule to sustain the robust vitality of our growing constitution. It embraces the seminal spirit of the rule of law that controls all the powers, even the prerogative power. Before parting, I say that the constitutional restraint and discipline are revealed from the words of the Constitution and the high constitutional functionary who should remain embedded to this with humility, because it is humility that forms the foundation of regard, which is the ultimate constitutional virtue. Nonetheless, all that the learned judge has said is contrary to judgment after judgment by this court, saying just the contrary. That we have seen speakers behaving in a particular fashion. We have seen the manner in which they have conducted themselves. Actually, it is Parliament who must change this system. I'll give those judgments to your lordships.
Now just let's see Justice Lokur. So,
Yes, Justice
actually,
Lokur.
Justice Mishra again refers to the words of all the members, all the then members of the
That's again the same thing.
He also places it on the ground that, there must be an impartiality of the speaker. So the moment there's an expression of an intent to remove him or them, he should first stand the test. So the moment, in fact, that means that Justice Mishra even goes as far as to say that the moment a notice is given, the initial notice, because he felt that otherwise what will happen is within the 14-day period for the notice, the speaker would remove these people, disqualify them.
That's right.
And that would affect the impartiality of the speaker. He places it on the ground of constitutional trust.
More than the interpretation, he is on the ground that impartiality of the speaker.
Because within that
he should
14-day
stand aside.
period, if the speaker is allowed to disqualify, that would affect his own impartiality. Because as an arbiter under the 10th schedule, he has to be impartial. That's what that's the constitutional theory with Justice Deepak Mishra.
Well, it's like saying, if I'm holding a constitutional office, then there's an expectation that I will be impartial. Now, the underlying this is the expectation that he will not be. That's the underlying theme of Justice Mishra.
What does Justice Lokur say? Let's see the
Yes.
Lokur.
242.
4042.
401.
4242. PDF 1224.
1224 PDF, paragraph 401.
To navigate. One.
No, para 396, I think.
Yeah, 396.
396.
Question here. 396. My Lord Justice Shah.
Chief,
Which one?
1223 PDF.
1223. Yes.
The question here is not whether the disqualification of 14 members of the Assembly is valid or not. That was a matter pending consideration in the Guwahati High Court, when the judgment in these appeals was reserved, but has since been decided. We're not concerned with the decision of the Guwahati High Court or the power or propriety of the decision of the Speaker. The narrow question is whether the Deputy Speaker could, by his order dated 1512, set aside the order of the Speaker, also dated 1512, disqualifying 14 members of the Assembly, including the Deputy Speaker. The Speaker gave notice to the 14 members of the Assembly on 7/12, them to show cause why they should not be disqualified. under the 10th schedule. Thereafter, by an order dated 1512, Speaker disqualified them from their membership in this assembly. As mentioned above, the correctness of this order and the procedure followed has now been decided by the Guwahati High Court, and the correctness of that decision is not before us. Speaker passed an order of 1512 inter alia on the ground that the Speaker lacked the competence to pass the disqualification order and that he had not followed the constitutional and legal procedure of his removal. He had lost his competence to pass the disqualification order since a notice of removal dated 1911 was pending. It was to come up before the Legislative Assembly on 1612. In passing his order on 1512, the Deputy Speaker purported to drive his power from the message given by the Governor to the Legislative Assembly, requiring the Deputy Speaker to conduct the proceedings of the House on the resolution for removal of Speaker. What is important to note is that the Deputy Speaker was to preside over the House on 1612. He certainly had no derivative power from the Governor dated 9/12 to take over the functions or to sit in judgment over the decision of the Speaker. That apart is now well settled by the decision in Kyoto that the Speaker, while acting under the 10th schedule, acts as a tribunal and his decision can be challenged only in a court exercising constitutional jurisdiction. It was held in Kashinath that even the Speaker does not have the power to review the decision taken by him under the 10th schedule of the Constitution. Under these circumstances, there is absolutely no question of the Deputy Speaker setting aside the order of the Speaker passed under the 10th schedule. It is also important to note that the Deputy Speaker himself disqualified from the membership of the Assembly by the Speaker, and he could certainly not have set aside the order passed against him and in respect of which he would be the beneficiary. There is no doubt that the Deputy Speaker had no authority at all to set aside the decision of the Speaker passed under the 10th schedule. The fifth question is answered in the negative.
Next paragraph.
In view, I am of the opinion that the view expressed by my learned brothers relating to the power of propriety of the Speaker taking a decision under the 10th schedule with regard to 14 members does not at all arise in these appeals. Well, let's look at another scenario. A notice is moved both against the Speaker and against the Deputy Speaker. It can happen, Madam. So, Madam, both will be disqualified. Then what happens to the 10th schedule? So this has far-reaching consequences on how our democracy is going to function in this country. And your lordships put it to me that the other concern is that he should not decide because he may be deciding in his own interest, Malas. That's what your lordships put to me. But Malas, the question is that as far as that is concerned, it is subject to judicial review. And the judiciary, if it says that he is wrongly disqualified, they'll be back in the House. And you can move a fresh motion.
But in the meantime, what will happen?
Nothing. You move a fresh
If
motion.
the disqualification is set aside,
Yeah.
what will happen? What will the consequences?
No, they will come back. They will come back and move.
It presupposes that it is decided within reasonable time. But supposing the court it takes time, correct that, what will be the position
that's-
in the interim period?
No, Malas, that's for
The
courts.
government will be.
Malas, I would request your lordships to not assume that courts will take. Malas, courts should not. This is our refrain has been throughout the last so many years that courts are taking time. Sometimes the court sits day after day to discuss what's happening in Rajasthan. When it comes to Goa and to some other assemblies, it takes years to decide. It's for the court to decide, not us, Malas. We expect the court to take up the matter immediately. But courts don't, unfortunately.
No, we are not on that. We are on the consequences.
Malas, but the point
It's
is,
not sufficient that it will be set aside.
yes. And
It
then
may
they'll
be
come
set
back.
aside, but what will be happening in between?
But that happens in every case of disqualification, Malas. Why should this be different? Let's forget about this issue. In every case of disqualification, Malas, he'll come back. What's the difference in that consequence and the one that your lordship is asking me? No difference.
And actually, Mr. Sibal, then your broader principle is this, that is a matter of constitutional principle.
Yes.
A constitutional authority continues to act as a constitutional authority unless the Constitution treats the authority of that constitutional authority as having come to an end,
Correct.
namely after the motion of removal is passed.
Correct, correct.
Until a motion of removal is passed, there is no cloud on the functioning of a constitutional authority.
That's right.
And unless the Constitution has imposed any express or implied restraint, that should not be read in, because he he, for all intents and purposes, continues to perform all the functions of a speaker until a motion for his removal is passed.
Yeah. Manoj, how is the 10th schedule in any way, Manoj, derogatory to what is happening in the House under 179C for the removal? Manoj, the court has at two places remarked that these are two independent functions. Your lordships have seen that?
Yes, constitutional spaces.
Yes, there are entirely different spaces.
There were only two principal arguments, and the two principles which held favor with Justice Keir and Justice Mishra eventually. One was the expression,
Then members.
then members of the Legislative Assembly, which is really on a completely different issue. The second is something which requires a little more, deliberation, which is Justice Mishra's position that if you don't read this restraint, then within that period of 14 days, that is mandatory for the removal, Speaker could, by the exercise of the qualification, to conduct the outcome of his own, which your answer is that, look, the Speaker's decision to qualify judicial review. Whereas
there is no
a motion for the removal of a Speaker is not a
and there is no constitutional assumption, Manoj, that we can make as a matter of law that the Speaker will act in his own interest and not in the interest of what is set out in the 10th schedule. You can't make a constitutional assumption of that nature. Either you say that the Speaker belongs to a political party, we know. The Speaker does not resign from that political party, we know. And yet we don't ever make a constitutional assumption that he's acting in favor of that party. We never make that. In ordinary cases, forget about this case. Do you ever say that? No, never. Why? Because he is a constitutional authority. The 10th schedule has empowered him to perform that function. The constitutional assumption is that he will not be swayed by party considerations. That he is may be a fact. But constitutionally, you cannot assume.
Well, one thing is very clear now, that para 193 of Justice Kehar's judgment and paragraph 238 of Justice Deepak Mishra's judgment, both the learned Chief Justices then were, make it very clear that according to them, once a notice for resolution of the removal of a Speaker is pending, a notice of the resolution for removal, then the Speaker cannot act.
That's correct. That's correct.
It's very clear.
That's correct. And that is based on, except that notice can happen. They don't fix the time when that notice takes place.
And logically, they are right in the analysis which they do, because they don't then bifurcate between the stage prior to leave being granted and after leave being granted.
That's correct.
So
They know that, well, the judgment, they're very clear that it relates the disqualification on this, or the disability on the Speaker entertain a disqualification petition attaches the moment a notice for the removal is.
That's correct.
They don't then bifurcate it at the stage when leave is granted.
No, either they don't. They don't, Manoj, which is the rules bifurcating.
Yes.
The reading of the rules bifurcate, Manoj, the manner in which this is to be considered. And they don't even tell us at what stage the notice is to be moved.
And the Speaker is not, according to, he doesn't cease to be a Speaker merely by a notice of removal given to him.
Correct.
Therefore, should the Constitution, should it be interpreted to impose that
the restraint
or disability, or a cloud on it because of the fact that a notice for removal is given to him.
And as I said, Manoj, there are the other parties, Manoj.
Really, it's a matter of interpretation, it's very short.
And there's the other issue, Manoj. There may be several petitions.
So anything else on the issue of, you've argued your point for reference, Mr. Sibal, anything else? So that we
No, Manoj, I'll just quite quickly, because there are some things that I have to point out. I've written submissions, I'll quickly read through them and then.
we can look at it. We can examine it. Now we are now looking at the other aspects. Should we come back after lunch?
Yes.
That we can.
You
You will only focus on your submissions. How long now for you? It's about.
Well, it's not too long, Manoj.
Your submissions with respect to reference.
Sorry?
Your submissions with respect to reference to larger text.
Reference one.
Yes.
That's all.
We are not.
That's only reference. I'm not on the argument. Because if your lordship then decides to refer.
Mr. Sibal, just for a little clarity, you don't have to spoil your lunch because of this last question. Ask one of your juniors to give us just on a piece of paper the facts in Nebam Rabia. Just
Yes, we've done
bullet
that.
point, just bullet points on the facts.
We've done that.
Just to have a little clarity, because we're now looking at the facts by reading the judgment.
We have already filed.
Just on a paper.
Additional compilation, one pager is already there.
All right, just that one pager we'll see, and then we'll go on to.
Yes, yes.
And then we'll call upon the others.
Yes. Deeply obliged.
హలో ఓలా చేసినావా హలో గులాబ్ చేసినావా దీంట్లోనే చేస్తున్నా దీంట్లోనే చేస్తున్నా చూపివా ఓ చానీ ఇదే నీ దగ్గర ఏడు చూపి అప్పిడు హలో 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 కెమెరా Hello,
So I just wanted my lord to look at the decision in Polohon for a minute. That also has a bearing on this. Paragraph 110 of Polohon, which is in compilation 1, page
74.
PDF 134.
134.
134.
Which para?
Well, let's kindly have it. May I, Your Lordships have it? May I read it?
Yes, we have it.
Your Lordship.
Kyoto judgment. Kyoto judgment.
Kyoto judgment. PDF 134.
PDF 74, but not.
132.
No, at the para 110.
Yes. I think 132.
Just your leadership may have that.
नहीं वो नहीं.
Start.
In view of the limited scope of judicial review that is available on account para
110. Yes, got it. Yes. In view of the limited scope
Yes.
of judicial.
In view of the limited scope of judicial review that is available on account of the finality clause in paragraph 6, and also having regard to the constitutional intentment and the status of the repository of the adjudicatory power, that is the Speaker Chairman, judicial review cannot be available at a stage prior to the making of a decision by the Speaker Chairman, and a qui-timet action would not be permissible, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. So, Kyoto assumes that there can be no interdiction by the court till the Speaker decides the matter. If you interpret 179 in the manner that Rebia interprets, you then automatically say that there is a stay as far as the Speaker dealing with disqualification petitions is concerned.
Yes.
It's the other problem.
Yes.
So you don't interpret one constitutional provision to derogate power of a constitutional authority vested in another constitution. So you have to actually provide a balance. And the only balance that can be provided is that he is not disqualified till such time as the resolution is moved and voted. That's the only balance.
Yes.
That's another point that I wish to make for your lordships. The other thing, Malad, that I am somewhat concerned about is that a 14-day notice is constitutionally provided. Then a 7-day period during the assembly. Now, Malad, supposing the 7th in the session for 3 days or 4 days. And if you, Malad, then in terms of the judgment of Nabam Rebia, if you interpret notice provision in a manner, he is automatically for a year or 2 years. So what's going to happen?
All.
The session will not be for 7 days, so it will continue till the next. And so, Malad, why would your lordships interpret these constitutional provisions in this fashion? By attributing or assuming that the Speaker will function in a manner when he's functioning as under schedule. The second provision problem that might, if you give notice to both the speaker and the deputy speaker, then there'll be nobody left.
Article 180, some other person will be appointed.
Can't be Malad under the 10th schedule.
Now 180 is, no, not 10th schedule.
I'm talking about the 10th schedule, Malad. Then what will happen? Because if the judgment is right, then there'll be nobody. But both, there'll be a notice for both. That also your lordship should not allow. The other issue with us is that now we are trying to balance between the removal of the speaker and the functioning under the 10th schedule. Let's take a case of small states. Most of these things happen in small states. You have a 5-member party, 2 of them move on to the other party, give a notice to the speaker, government falls, and those matters are not decided. So it has disastrous consequences. Then look at it from another standpoint. Look at it from the point of view of paragraph 3 of the 10th schedule, that's been repealed. What did paragraph 3 says? You must have at least 1/3. At least 1/3. That's repealed. Why? Because they thought that was also being misused. Now, if you interpret 179C in this fashion, that 1/3 comes back to the back door. Because 1/3 in an assembly can topple the government. So paragraph 3 having been repealed, Malads, 1/3 can still topple the government, and a notice under 179 will freeze the hands of the tribunal. So in a sense, you're bringing back, through this interpretation, a small minority in an assembly, who then, Malads, for reasons that we all know, go to the other side, and Malads makes the government fall. And then you say, no, but the speaker may have, maybe we should not have allowed the speaker this time because he may. Ultimately, if the speaker is removed, let's put it this way, if the speaker is removed, he's only removed from one office. There'll be another person who will be a speaker. But if an elected government, is actually toppled by this subterfuge, the harm to the polity is much greater. Look at it from that point of view. Because if supposing the speaker is removed and it is found that actually these persons were disqualified, should be disqualified and are disqualified, speaker can't come back, get back to the office. But when people who are disqualified, they are not disqualified, they can come back to the office. Judicial review is available. So from any standpoint, you can't balance the two. You're talking about one man moving a notice, sway one person, and you're talking about the whole polity and the whole 10th schedule being misused. Proper elected. There is no way that you can balance between the two. The only balance is that you cannot allow the elected governments to be toppled.
Yes.
Well, as now I was reading to your Lord, I would like my note. Yes. I'll just quickly go through it. None. This is brief submissions on behalf of the petitioner for reference. Final note on.
Final note.
Serial number C in the PDF.
Revised supplementary.
Supplementary. Give it to
They
me.
have.
Whereas we had detail for everything. That was chapter 3, which is neighbor review. Now that chapter 3 is supplanted by this. This is what should be seen.
Yes, correct.
No, this is a special of why the reference should not be.
That's right. It should be made.
Should be made.
Should be.
if your lordship had.
Yes.
It is respectfully submitted that there is an imperative need to reconsider the law laid down in Rebia, and it would be constitutionally impossible for the Speaker to adjudicate upon disqualification petition. That's plainly wrong according to us. Present case epitomizes the need for reconsideration, as the respondents misuse the input of the observations to obtain key Tibet intelligence from this very moderate. So this is what happened. On 27th, this court said we'll give them till 12th July. So that on the ground of 2 days notice and Nabam Rebia. Para 110 of Kyoto Holohan says that you cannot interpret before the final decision of the Speaker. That's what 110 says. It's only when during the proceeding that somebody is disqualified, then only you can. But not before. So the result, it is really the problem that is created by the order of this court on 27th of June, which is contrary both to Holohan as well as my submission that Rebia delighted. It's that ultimately led to the toppling of the government. So, Malad, the respondents then abused the process of law by unlawfully appointing a speaker in the assembly who is completely biased against the petitioner. Let's not go into this because we are not your lordships. That's only the pure question of law, so I won't be fair on my part. The impugned